Vandyke Jude against Nolan nee Jude and Vallery Jude Porter.
First of all, may I apologise for the delayed start. There were difficulties with my laptop this morning, which have now thankfully been resolved, and we will make allowance in the timing for the fact that 5 minutes have been lost.
Thank you, my lord.
Before you commence, can I just raise one matter with you? Very recently, the respondents lodged 3 documents. Were you given them in advance to consider?
Yes, my lord, I received them on Friday evening.
You received them on Friday, and were these matters which were in evidence before the judge at first instance?
To the extent that they record what is in the documentary record, yes. Whether all of these points were made to the judge orally is another matter.
What is your position in relation to the late production of these documents?
I don't object, and I don't expect to take much time over them either.
I see.
Oh yes, as long as we get some explanation of what they're telling us.
Yeah, just an explanation.
Yeah.
Respond.
Well, from whoever they know.
Perhaps if I could ask Mr. John Shabby to explain why they were produced, when they were produced, please.
Thank you, my lord. Essentially, the document is a table which provides the references of some of the deeds of sale, which is in the bundle. So it's basically a quick reference in terms of identifying the precise location in the bundle where the documents are. That was the sole purpose for which.
Yes, but is it going to be used to advance arguments that were not advanced in the courts below?
Not at all.
Not at all. Well, we shall proceed with these documents, de bene, I say.
Could I just ask before we leave that? In effect, you're saying that this is just a quick reference guide to what's already in the document.
That's correct.
That's true, is it, as regards the evaluations? As regards the right-hand column?
Yes, that's correct.
Thank you very much.
Fine. Thank you, Mr. Strang.
Well, my lords and my lady, I'm Mr. Strang. I appear for the appellant in this matter. My learned friend, Mrs. John Xavier, appears for the respondents. And before I begin, I believe this may be the last time that the flag of St. Lucia will hang in this room. So I will.
So I believe.
Endeavour to do the occasion justice. So this is my appeal against the decision of the Court of Appeal, finding that 2 transfers of land to the appellant, who I will call Vandyke, were the result of undue influence exercised by him over his father, Austin. And the Court of Appeal's first error in my submission, was that it reached that conclusion despite the fact that it ran contrary to decisive and undisturbed findings of the trial judge. Now, the trial judge had familiarised himself with all the evidence. He took care to understand the relationships between the parties and how the relevant decisions were made. He found Vandyke and his sister Diane to be telling the truth, and he accepted their explanations for the relevant transactions. He found nothing unconscionable in their behaviour towards Austin. And he made 2 decisive findings. First, he found that neither Vandyke nor his sister Diane had in fact exercised actual undue influence over Austin. In my submission, that finding was, or should have been, an end of the case on undue influence. And the Court of Appeal didn't disturb it, accepted that it was a finding the trial judge was entitled to make. But it found, nevertheless, that a presumption of undue influence had been raised and had not been rebutted. That, in my submission, was an error of law. And the Court of Appeal fell into that error by treating actual undue influence and presumed undue influence as two distinct categories, with the result that it wrongly thought it possible to make a finding of presumed undue influence alongside a finding of no actual undue influence.
I'm sure you're going to develop that.
Yes. Yes, I am.
If I could just say initially that my understanding of the law is that you've got one concept, which is undue influence. This is after Ettridge.
Yes.
You've got two ways of proving undue influence. One is by proving actual undue influence, direct evidence of actual undue influence. The other is presumed undue influence.
Yes.
So it is perfectly possible to say that the claimant has failed in proving actual undue influence, but is nevertheless successful in relation to presumed undue influence. That is not the same as saying that you have failed to prove undue influence, and then, of course, that answers everything. That's the end of the case.
I accept that, my lord. But a finding made, well, I'll develop it more, but a finding made after trial where there's been evidence given about the very relationships and the very transactions and how the decisions were made in my submission, and a finding that no undue influence was exercised in those transactions, in fact exercised, does in my submission eliminate the presumption. And that's what happened in this case in my submission.
So you're saying the trial judge should be treated as having decided that there was no undue influence. I'm just balking, and it's really important to balk,
Yes.
at he clearly found that there was no actual undue influence, but that seems to me very importantly distinct from a finding of no undue influence.
And if he found so in the absence of enough evidence to make a decision about what happened with the relevant decisions, then in those circumstances perhaps the presumption could still operate. I accept that. But that's not the case here, my lord.
I wonder if it might help escape from terminology that may mean different things to different people if one thinks about whether the defendants proved that they did not abuse the relationship they had with their father.
Indeed, my lord, and when we look at all the findings the judge made, I say they did, as far as he was concerned.
Yeah.
Yes.
Now, the second
Your
finding...
position, as I understand it, is given the badge of credibility to Diane and to Vandyke, what they say in their witness statements is treated as having been accepted by the judge.
Yes.
In its entirety.
But I do say that, yes.
Yes.
And certainly if the Court of Appeal were going to find otherwise, they needed to address all
Yes, but
evidence.
out of the blue comes this statement that this is totally incredible, without any analysis as to why that is the case.
Exactly, my lord.
Yes.
And the second finding that I say the judge made, which eliminates the Court of Appeal's finding, was his finding that the transfers in question were explicable by ordinary motives and were not such as to lead to an inference of undue influence. Now, the Court of Appeal found to the contrary by singling out and rejecting one of a number of factors explaining the transfers that were said to explain the transfers. But it didn't even address the judge's finding or the reasons for it, let alone identify what errors of the judge entitled it to make a contrary finding. So,
one of the things I'm interested in is whether these tables that we've got say anything about what parcels of land, either because of Austin's death or because of earlier transfers, whether at the time of the original petition or at the time of the power of attorney or later, actually ended up with the claimants. because it seems to me that one of the things that was concerning the Court of Appeal was their assumption that Vandyke got all this land for free, and the presumption that the others didn't get anything. But I gather that's contested, and I'm not sure whether there are findings that you can point to, or whether we gather from these tables that actually everybody got something.
Yes, I will go into some of the details, in particular about the land that was transferred by the two deeds. Aside from that, I suppose I could summarize it by saying that as well as the land that was transferred by Mr. Montplaisir in 2006-2007, we know that a large number of parcels had already been shared out between the two men earlier.
Yeah.
23 had gone to Austin Shield
Shield,
Company. Yeah. We know that of those, 10 were transferred to Sheila, the mother, by order of the Court of Appeal, after Vandyke had persuaded his father to do so. 4 were transferred away to Austin's sister and cousin during the divorce proceedings to hide them from Sheila. 3 of those were transferred back.
Sorry, Mr. Strang, can you keep your voice up? I'm just struggling perhaps with the movement at the back of the court. Yeah.
3 of those were transferred back, again at Vandyke's behest. Perhaps I could do is get all the reference. I haven't got all the references for these. I wasn't planning to go through all of the details, but I can get them by the end
Sorry,
of the
my note stops at 10 transferred to Sheila during the divorce. I think you then said 4 were transferred, and I'm afraid I lost it after that.
Yes, 10 were transferred to Sheila as a result of the Court of Appeals orders in the divorce.
Yes.
As enforced by Vandyke,
which Vandyke had to enforce in 2005.
And did that, were the 3 from the sister and so on, were they part of the 10?
No, they're separate.
These are separate.
I mean, are you now about to explain to us all the property transfers? Because I will take a comprehensive note if you are. But at some stage, we need it. Right. We need to know what the impugned transfers are and the broader picture insofar as that's relevant.
I am going to give Your Lordship the impugned transfers. I will go through the evidence as to those in detail in the findings.
But those are not part of the 23.
No.
No. So the 23, say 10 went to Sheila.
Yes.
At her choice. Then there were the ones to Martina and Loretta, which then also came back into.
Well, one of them didn't come back. One of them was transferred to Beverley in 2001.
Right. But I think it's important for us to understand what of that original 23 or other land actually went, whether because they inherited the Austin Shield properties or elsewhere.
So far that leaves
Della
9 in Austin Shield.
Yeah.
So you're now about to give us the comprehensive picture I requested, are you? Because then I will take a note and I'll have it all down.
Well, I'm not able to give Your Lordships a note with all the references for all
I just want what you say the facts are.
Certainly.
And then if there are problems with the references...
Certainly. Well, let me continue.
Are you saying that you are going to send us a note with the full picture? Because I personally would find that very helpful, if that were possible.
Certainly I can do that, yes, my lord.
Yeah. But so far you've told us 10 to Sheila in the divorce enforced by Vandyke, 4 other sites, 3 were transferred from the sisters back to
Diane.
To Diane.
They were challenged in these proceedings and found.
That's the Martina and Loretta ones.
Yes.
Yeah.
1 had already gone to Beverley.
Yes.
Yes, and then 9 remained in Austin Shield.
Well, out of those 23.
So, sorry if I can go right to the beginning. When were the 23 vested in?
It's 1984.
1984. 84?
Yes.
So
that's the transfer to Austin Shield.
And transferred to Austin Shield by Austin in 1985. He incorporated Austin Shield in 1985.
So 23 parcels vested in Austin Shield in 1985, right.
And you've explained, so 10 plus 3 plus 1 plus 9. Yes.
Yes.
Thank you.
Now, we can also see that over the years...
But the ones that went into the 9 remaining in Austin Shield, are they still there, or when Austin died, did those go into his estate, or what happened to those?
Well, the estate the will hasn't been probated yet, I believe.
So, just to be clear, there are still, therefore, 9 owned by Austin Shield.
I'm not sure whether we know for sure whether all of those 9 are still owned by Austin Shield. And I will say one further thing about Austin Shield's ownership, is that after the initial 23, we can see that over the years, Montplaisir must have allocated more plots to Austin and/or Austin Shield, because the plots that the names or numbers of the plots that you see the family talking about distributing and sharing out from Austin Shield include numbers that weren't in the original 1984 allocation. And there are 1 or 2 references in the evidence to Montplaisir allocating plots to Austin after 1984, but before the events of this that gave rise to this.
But you mean that the legal title to those plots was transferred to Austin Shield?
Yes. So, all I can say about what's in Austin Shield, that there's an unknown number of plots that includes plots beyond the original 23.
Okay, and do they have those plots which are still vested in Austin Shield? Do they have any relevance to the appeal before us?
No, save that it is background in that it shows that the impugned transfers and the challenge transfers in these proceedings did not cover all the land owned by Austin.
What's the relevance of that?
No great relevance other than its background.
Well, it may be relevant in so
not entirely disinherited.
Well, quite. If the Court of Appeal thought that the reason why these transfers called for explanation was in part because it looked to them as if Vandyke had got everything as a gift, then they were not taking into account the fact that there had been other transfers of land and there was still land to be distributed amongst the family.
Exactly so, my lady.
Do we know what the provisions of Austin's will are as regards the as to what is to happen to the shares in Austin Shield? Because that will determine who gets the properties.
But the will itself it may be contested, as I understand it.
Yes, it hasn't been proved, and it came about in contested circumstances.
Yes,
right.
In the last days of Austin's.
But is it right that Austin Shield shares are owned by the deceased?
He and Diane between them own the majority of the shares.
Right.
I can give
Austin and Diane.
Austin and Diane. But there's evidence also that he treated the properties held by Austin Shield as his to decide what to do with.
I see.
But the
last comment was...
There's evidence that he treated the properties owned by Austin Shield as his to decide what to do with.
Yes.
Yeah.
But the contested will, or at least the will that's not been probated, I think that purports to leave everything to the children equally.
Yes, it shares. It doesn't identify specific parts of the estate. It just leaves it to the children equally. I mean, one example of the properties in Austin Shield being treated as Austin's is, of course, the Court of Appeal's order that Sheila could take 10.
Yeah.
Yes.
And just finally, just to clear the air, does the sublucian provision in relation to intestacy, if the will were never probated, and assume there's no earlier will, for there may be dozens, produce the same result as the will?
I don't know the answer to that, my lord, but there was an earlier will.
Oh, right.
So I will then go in due course to the actual impugned transfers and show what I say was being transferred then, what interests were being transferred by who, because the Court of Appeal got that very materially wrong.
Yes. You have an analysis in your written case on this matter.
Yes.
Was that were those matters led in evidence before the trial judge?
Yes, and you can see where the judge, I'll show you where the judge understood them and where the Court of Appeal understood them.
Thank you.
Together, the two courts.
Well, we better let you develop your submission.
Thank you. Yes.
Well, can I just say this? We're sort of going to have to decide this, aren't we? Being unclear what shares and what other land is going to potentially the other members of the family.
Yes, I'm afraid so, yes.
Yeah. So we almost have to say, well, we don't know what's happening on that.
But there are these other assets which were part of Austin's estate. Yes.
And there were lands also at a place called Sarro and at a place called L'Abbaye. And they're referred to in the particulars of claim.
I mean, what I'm driving at is, if the picture is that Vandyke, in the transaction that we know about, is reaping a very significant benefit, we can't, at the moment, as I understand it, offset that by saying, oh, well, it may well be that that sort of benefit is actually matched by what other members of the family may be getting.
Well, your lordships can't assess exactly how disproportionate the benefit may be. But it's not, and Vandyke and Diane are by no means getting everything.
What we know is that there are these other assets, but precisely how they will eventually be disposed of, we don't know.
Yes, I can give your lordships in due course a reference to both wills.
Yes. Okay.
But the earlier will did not include Vandyke.
Did not include?
Did not include Vandyke.
Right.
Yes.
But the later will, the children are all treated equally.
Children equally. Yeah.
So if one were to proceed on that basis, then plainly you can leave, in one sense, leave out of account the remaining properties and then just see how the impugned properties are being distributed.
Well,
because clearly that's a sort of, anyway, we'll think about it. Don't worry.
If Austin did make that will, having already agreed to what I say he was already agreed to in the and covered by the impugned transfers, then he must have understood that he wasn't going to be dealing with those assets, save for what I will identify as a minority of them.
But at the time, so you're saying at the time of the impugned transfers, the will did not leave anything to Vandyke.
That's right. Yes.
I see.
Yes, well, that could be material.
Yes. So I dealt with why I said the Court of Appeal wasn't entitled to make a contrary finding about explicability of the transactions. And the final thing I'll say by way of introduction is that the Court of Appeal also, as we've just been discussing, materially misunderstood what was being conveyed transferred by the conveyances in question, and the explanations given for them. So it didn't identify a sound basis for a different finding to that of the judge, and it didn't identify a sound basis for the orders that it made, because it ordered all the land in those two impugned transfers to go into Austin's estate. Yes. Even though it's undisputable that not all of it belonged to Austin in the first place.
Yes, I mean there were some things sold by Montplaisir to Vandyke, and then there was a transfer, I think, of plot 157 in respect of legal fees, for example.
157 is an earlier transaction.
Yeah.
But there were other transfers by Austin to Vandyke for value,
yes.
By Montplaisir to Vandyke for value.
You'll be coming to this.
Yes, I will.
Yes, well,
sorry, yes.
I do want to let you develop your submissions in a logical way.
Thank you, my lord. Well, I'm going to come to that now, actually, because in my structure, I intend to, first of all, explain the relevant transfers, then go through the judge's findings and their effect, and then the Court of Appeal's findings and the errors that the Court of Appeal made. And I won't dwell on the law right now. I will go into some more detail when addressing the Court of Appeal's errors. For the time being, I'll just say that I take the law as it's summarised in the board's judgment in Nature Resorts, which is in the bundle, and paragraphs 10, 11, 12, 13 at page 2454. I'm taking that as a succinct summary of the relevant principles applying to this case, given by two members of today's board, with the agreement of a third. So perhaps it's worth just having a quick skim of page 2454. And one of the issues in the case is that raised at paragraph 11, single concept with two ways of proving it. And I also adopt at the bottom of page 12, what's the nature of the transaction should we reach the presumption? One that absent evidence to the contrary must make one conclude that undue influence has been exercised in the context of the relationship. And over the page at 13, it's also relevant what's said there, that independent advice is not the only method of rebuttal of the presumption. Now, I said I would go through the impugned transfers in particular.
Yes, I mean, the key passages at the end of 13, although neither necessary nor conclusive, the main method of rebuttal is to show that they obtained fully informed and competent independent advice. Yeah. But what the board is clearly saying is that's not the only way.
Yes. And indeed, in this case, the presumption was rebutted not by independent advice, but by the judges and the Court of Appeal's findings that the component in question knew what he was doing and wasn't being influenced by anyone else.
Yes.
You appear to concede in your written case that it's an irrebuttable presumption as between lawyer and client. One doesn't get that from this judgment, I do.
No.
I just wonder why you make that concession.
Well, because it's the law as stated by Lord Nichols in Ettridge.
But then Lord Scott in Ettridge, A, that wasn't the case about lawyer and client.
It's true.
B, Lord Scott in Ettridge says that it's rebuttable in both Class 2A and Class 2B, brackets hopefully exploded, close brackets, classes. I just wondered where there's any very clear statement from a highest court that it is actually irrebuttable.
The most recent statement by the highest court was and this may also be overturned. It's in the case in Sumati Inal, which is also in the bundle. And that judgment was given by Sir Nicholas Patton. And he said it was almost irrebuttable.
Ah.
I mean, can I just refer to paragraph 29 of the case you're referring us to, Nature Resorts, page 2462.
Yes. Yes, and as I've said, I've referred to the article of Sir Ken Lewison in my case and said that there is a persuasive argument against the presumption being irrebuttable in that article. And well, when I get there, the approach I take will take is that if one did have to presume that because Austin is trusted to Vandyke is trusted to give Austin legal advice in respect of some matters. One still has to understand the nature of the relationship. In respect of what matters was Vandyke trusted, and in respect of what decisions did Austin rely on him. And when you look at the judge's findings under influence, you'll see that they limit the scope of the influence to almost nothing. And so, in a sense, I suppose I'm dodging the difficult argument whether I need to establish that it's irrebuttable, because in my submission it doesn't matter on this case. I know it's interesting.
Even assuming it's irrebuttable, that just tells us the relationship. Ultimately, it can be rebutted, and you say, the undue influence can be rebutted. The presumption of undue influence can be rebutted.
Well, also one needs to understand. Supposing I did have influence over, supposing Vandyke did have influence over Austin, one needs to understand in respect of what matters, generally and in fact in this case, and then see whether that influence was at all being exercised in this case. Because if I was Austin's tax lawyer, I might be trusted to advise him when to transfer his holdings to his family to avoid inheritance tax, but I might not be trusted in respect of another decision.
I think Diane wrote at one stage to the family that unfortunately father is incapable of managing his own affairs. And wasn't that really Vandyke's function here?
Well, we'll go into it in more detail.
I mean, it wasn't narrow. I mean, I understand your point about a tax lawyer, but that's not our case.
No, but when you see how the judge makes findings as to how the relationship worked in practice, Vandyke was not generally managing Austin's affairs.
Yes. Well, again,
he was asked to deal with negotiation.
I would urge everyone to let you develop your submission.
Thank you.
Because you've got limited time.
Yes, indeed. 35 minutes, okay. All right. So, I'm going to explain the particular impugned transfers. Now, I don't want to dwell too long on the details, but if I pick it up at 89, paragraph 12, this is the task that Vandyke was asked to help in this. I mean, the judges...
Sorry, where
the judgment at paragraph 12, at page 89.
The first instance judgment.
First instance judgment.
Yeah.
So, Vandyke's been asked to come back to assist his father in recovering the remainder of the unpartitioned land that Austin jointly held with Mr. Montplaisir. Now, that land was all at Marigot Bay, and it can be divided into two categories. The first is on the north shore of Marigot Bay, and the two men jointly owned an undeveloped 16-acre plot of land, what we'll see referred to always as the North Shore lands. And as a result of an order of the Court of Appeal in the divorce proceedings, that land was owned 50% by Mr. Montplaisir, 25% by Austin, 25% by Sheila. But title was in Montplaisir's sole name. And the order is at 1566. And that's also the order that Austin transferred 10 plots out of.
Sorry?
That's also the order that Austin transferred 10 plots out of Austin Sheila for Sheila. So, Order 1 at 1566 is the transfer of the 10 plots. Order 4 on 1567 declares the beneficial interests in the North Shore lands. Now, the Court of Appeal estimates them at 12.5 acres in that order. A more accurate estimate is 16.
I think I got my page number wrong.
Yeah,
Did you say 1556?
1566.
Ah, thank you.
And then the second order at 1567 is...
So Order 4 at 1567 is the Court of Appeal declaring the beneficial ownership of the North Shore lands.
This is part of the divorce.
Yes. So that's the North Shore lands, 50% Montplaisir, 25% Austin, 25% Sheila. On the South Shore, the land owned by Austin...
I mean, this paragraph 4, so I'm just wanting to get this right. You referred to 10 parcels, but they don't come out of this land, do they?
No, they come out of...
Sorry, I misunderstood.
Paragraph 1.
Yeah, I got it. Yes, this hasn't been parcelled up, the North Shore,
No.
has it? No.
No, it hasn't. So that parcel 0443B4 is the North Shore land.
Yeah.
And the Court of Appeal are declaring that Austin and Sheila own half of that.
But is paragraph 1, does that relate to the North Shore too, or does that relate to something?
Paragraph 1 relates to South Shore. Those are...
That's what I was about to say, 10 plots on the South Shore.
I beg your pardon, I wasn't clear. That's the 10 lots that we were talking about earlier. That's South Shore. Yes.
Do you have a registration number for it, or is it all, they all 10 got different numbers now, I suppose?
Yes, I do have a reference for the transfer that took place later.
But, I mean, paragraph 1 is a bit of a red herring, isn't it?
Yes, that's what we were talking about earlier. That's the background.
Exactly, yes.
That's the background, yes.
But that was one of the conditions that Vandyke imposed on Austin to take this job on, was that he should honour that,
should honour that order, yes.
So from this, what we know is the equivalent of 4 acres of the 16 acres will be part of Austin's property.
And 4 will be Sheila's.
And 4 will be Sheila's, yes.
Now, the South Shore, which is... that had been divided up into smaller parcels. And originally, title to all of them was in Montplaisir's name. Over the years, he had transferred many to Austin. As I set out earlier, the 23 in one large allocation, and some later allocations, the exact numbers of which I can't tell the board. But the point about the material point for the impugned transactions is that at the time Vandyke was asked to come and help, there remained a number of parcels registered in Montplaisir's sole name in which Austin had an interest. And the issue to be resolved was how many should Montplaisir transfer to Austin. And that depended on the resolution of a number of disputes between them, especially Montplaisir's claim that Austin owed him a lot of money. And as my ladies identified, there was a further issue of importance to Vandyke, which was that Austin had transferred some of his parcels to his sister and his cousin and hadn't yet complied with the Court of Appeal's order. And Vandyke wanted his father to do right by his mother, and that explains the conditions, some of the conditions, he put to Austin. And those are set out by the judge, page 90. Your lordships and your ladyship will have seen these. And the result is described at 17 on page 91. And all of the transactions the judge describes there, the grant of the power of attorney, the transfers of 3 lots to Diane, and the transfer of 157, 147, and 148 to Vandyke. They were all challenged in these proceedings, but the judge found nothing untoward in those transfers. They're no longer an issue.
But the last 3, were those the ones where the problem was that there was the caution on the register?
Yes.
But they were in fact then sold directly from Mr. Montplaisir to Vandyke.
No, and that tells us that Vandyke was already had already been negotiating with Mr. Montplaisir on his own behalf, because before he agreed to work for his father, he'd already agreed with Mr. Montplaisir to purchase 147 and 148. And you may recall that Vandyke's familiarity with this land had come about partly because he'd helped his mother in the divorce proceedings, partly because since then he'd been helping his family by developing some of the lands and redeveloping the matrimonial home on parcel 48. But the transactions that are in issue in this appeal concern the later transfers of land, which were agreed and signed in August 2006 after negotiations with Mr. Montplaisir were concluded, but weren't executed until July 2007. And that's why they're called the July 2007 transfers.
So agreed and signed? Did you
Yes.
say? What was signed?
Parties signed deeds in August 2006.
Right.
They weren't executed by the notary until July 2007. And
Yes.
that chronology is explained by the judge at page 92, paragraph 22. Vandyke had explained to the judge that after he and Austin had worked out which of these being transferred by Montplaisir is Vandyke's, which is Austin's, they were waiting on a decision from Austin as to how he would distribute the remaining parcels that were his to distribute. And the idea might have been that if he decided to transfer them to his daughters, separate deeds would have been executed. And it was only when Austin decided to leave it all with Montplaisir that the deed was executed in the form...
With Vandyke?
Sorry, to Vandyke. Thank you, my lady. I'm going to come to that in more detail.
Surely.
I'm going to just show your lordship and your lordships and your ladyship the deeds. They are 1837. They're not actually the original deeds. The registry describes, provides a copy. But these are the 13 parcels. 1837. Sorry, 1837 is not the 13. 1837 is the 3 parcels. 2 small plots on the South Shore lands, 51 and 52.
So this is, we're looking at 1837 at the moment?
Yes.
So this is 3 plots?
Yes, a half share in plots 51 and 52.
Right, where? Oh, yes. Okay.
And they are South Shore lands. And then 444B number 4 is the North Shore lands. So by this is how half share in the North Shore lands and the other two plots is conveyed to Vandyke.
I see.
And all these say in consideration of $75,000, but
Yes.
was that actually paid by anybody? Or is it just to calculate the stamp duty?
Yes, I believe the latter. Vandyke accepted that these sums didn't reflect an actual payment or valuation.
But I didn't quite catch that. So what's the point of that payment? What's the point of the $75,000? What's that there for?
I'm not sure whether there was a clear answer in the evidence, but it's accepted it doesn't reflect a sale price or a valuation of the lands.
A lady mentioned something about stamp duty.
It may have been, that might be a reason to stick a value on a transfer, but I can't say whether it was in this case. As far as I'm aware, there wasn't a clear answer in the evidence as to why that number was chosen.
But
Anyway, for our purposes, it's neither the sale price nor the value of the land.
Exactly, my lord.
it means they're not gifts, is that right?
Well, I'm going to show the evidence as to why they weren't gifts.
Why
they weren't gifts.
weren't gifts?
They were not gifts. But the true consideration paid for them on the evidence is not recorded in this deed. The second deed is at 1840.
And I thought both courts had been proceeding on the basis that they were gifts.
Not the judge. Court of Appeal, yes, thought wrongly that these represented gifts by Austin to Vandyke of all the properties transferred by these two deeds. And that was wrong.
This is the 1840 is the 13 plots.
Yes. So those are 13 plots of
All
South Shore lands.
Yeah.
All South Shore lands.
Sorry, but what I mean to say is that the payments or the sum of $75,000 is not the reason that you're saying they're not gifts.
No.
No. It's for other reasons. So in a sense, the $75,000 is we should treat it as if it wasn't there.
Yeah.
Yes.
But it's of no relevance to our assessment. It presumably was a figure agreed for stamp duty purposes. One suspects, but one doesn't need to determine.
Thank you.
Yes.
Now the Court of Appeal treated these two deeds as constituting a gift of all 16 properties by Austin to Vandyke, and that was wrong. Now the deed we've just looked at, 13, that was not a gift of 13 parcels by Austin to Vandyke, because it included parcels which Vandyke had bought from Mr. Montplaisir outright.
Which parcel was that?
They were 45, 46 and 47. I shall go to them shortly. In respect of which, according to the evidence, Vandyke's evidence, Austin had never had an interest. So there were those bought by Vandyke from Montplaisir. Then there were parcels in which...
Austin never had an interest in 45, 46 and 47.
Yes, according to Vandyke's evidence.
According to Vandyke. And what, they were owned by Montplaisir?
Yes.
I see.
Legally and beneficially.
Yes.
And Vandyke bought them from Montplaisir.
Yes, for reasons he explained in his evidence. To enable the better development of the main family plot.
So I suppose the question is, well, why did they go through Austin in that case, under these transfers?
A question not explored in those terms.
Are there findings that these parcels that Austin had no interest in these parcels?
Well, I'll show you how the judge understood the evidence.
Yes, that's what I mean, yes.
And then there were parcels in which Vandyke had bought Mr. Montplaisir's half share, so that with the result that those parcels were now jointly owned by Vandyke and Austin.
And which were they?
They are 41, 55, 138, 162, and 223.
138, 162,
Yes,
and 223.
now I'll show you the judge's understanding of what he had been told. It's fair to say he doesn't go into detail. It's at paragraph 18. Vandyke stated that prior to, as well as during the negotiation, he
This is
purchased...
at page 92.
Sorry, did I forget to give the page number? Apologies. Page 92,
Yes.
paragraph 18. So Vandyke said that he purchased, so prior to, as well as during the negotiation, he purchased several parcels of land in which he had an interest from Mr. Montplaisir. Now, I understand the judge to be saying these were parcels of land in which Vandyke had formed an interest in buying and developing, not in which he had a beneficial
No,
interest.
that's what I'd gathered eventually.
So that following the partition with Montplaisir, he held the lands he'd purchased from Mr. Montplaisir jointly with Austin. Now that actually doesn't fully accurately record what I've just told you about Vandyke's evidence, because some of them Vandyke owned wholly.
45, 46 and 47
Yes.
is applicable to.
Yes. Now Vandyke's evidence is at page 1448. Paragraph 77. This is where he describes his reasons for and the purchase from Montplaisir of.
Yes, the three plots were protecting the immunity of the matrimonial.
Yes, from development by the hotel. Yes. That's why that's the three plots, and then the five in which he bought Montplaisir's half share. They're at page 1450. Paragraph 85.
Page, I'm awfully sorry, the page number.
Yes.
Page 1450.
1450.
Paragraph 85.
Thank you.
I thought I heard you say 233, but it's 223, isn't it?
It's 223.
I thought it was 223. It's what?
223.
223, yes. Yeah.
Now, in addition to those purchases from Mr. Montplaisir, the deed also included two parcels which Austin had agreed to transfer to Vandyke in return for the money Vandyke had spent on developing the matrimonial home. Vandyke had spent several $100,000 on developing the family home at plot 48, and in order to give that free of his interest to his siblings, and in the end to Diane, he agreed to take 2 other plots from Austin, and they were 160 and 211. Now you don't see the judge expressly referring to that, but strangely enough we do see the Court of Appeal acknowledging that evidence.
Is this in his evidence?
Yes, it's dealt with in Vandyke's evidence at paragraph 106. While we're there, let's go.
Paragraph?
106, page 1455.
I think what you have in your favour is obviously the judge's endorsement of the entirety of Vandyke's evidence.
Yes, I do say that. And
sorry, which paragraph was it?
paragraph 106.
106, I got it.
The last
Yeah.
sentence, parcels 160 and 211 were my compensation for giving up ownership.
Yes, thank you.
And these are included in the 13 South Shore plots in the deed in
Yes.
1840.
Yes.
And the Court of Appeal said...
The Court of Appeal noted that evidence at page 342 in a different context, paragraph 78. So this is where the Court of Appeal's dealing with transfers to Diane of 48, 56 and 103. And this is the Court of Appeal's giving its reasons for finding that 48 must have been valuable. And so one reason it must have been valuable is that Vandyke says he was reimbursed for his expenditure on it by land from his father.
And that's Court of Appeal paragraph
78, page 342.
342.
And that's referring there to Vandyke's evidence that we've just seen. And that agreement's also recorded in Diane's email on which the judge placed reliance. The email of 21st of April. I'll just show you quickly that one. It's at page 1807, and it's the last page. Last paragraph, sorry.
1807.
1807, last paragraph. This is Diane recording the state of play in April, and the judge recited this letter in his judgment. So,
Yeah, Oh, 04. I see. So,
South Shore 211 and
yeah,
160.
Yeah.
So, by those 3 agreements, of the 13, Vandyke owned 5 outright and a half share in 5 more. Now, actually, there's one further development before Austin's decision that the residue goes to Vandyke, which was that Vandyke said that he and his father then decided, rather than have half plots, who's going to take what plots. And that actually ended up with, that reference is at 1455. Paragraph 109. So, Austin retains 4, and he's going to decide how those are going to be distributed. So on the face of it, Austin's gone from 5.5 to 4.
So there's 46, 47, 122 and 177. Now 46 and 47
were ones which Austin had bought outright, but was now...
Vandyke had bought out.
Sorry, Vandyke had bought outright, yes. But he was now giving to Austin in return for half shares elsewhere, so that they effectively reallocated between them at this stage.
It says retain ownership. Not quite right in relation to...
No.
It's a transfer of ownership.
Yes. He was to move forward with ownership of.
So he's giving those two, and the other two were still in Austin's possession, 122 and
Yes.
77.
Yes.
Yeah. Thank you.
I'm sorry, why would he be doing this? Why is he giving back or giving to Austin?
Well, Van Dyke explained that the two men were deciding who wanted which parcel.
Presumably, the ones that are contiguous, it's better if they're all owned by... Is that the geographic location?
Explanation for 46
and 47 would be the immediate land for the
48.
all the family's houses.
Yes.
Yes.
But the parcels of which Van Dyke bought Mr. Montplaisir's half share, 41, 55, 138, 162, 223, so that then Austin and Van Dyke owned them jointly. What happened to Austin's share?
By this agreement, he's giving them up to Van Dyke.
But that's not the same. Oh, I see. That's 107. Paragraph 107.
Allocation.
Oh, I see.
Except that particular allocation wasn't really explored by the judge as to who did better or worse out of it. I can't say on the evidence because all the plots are different in size and value and state of development. Except that's a slight lacuna. But the result is that when Austin in July 2007 says, just give the residue to Van Dyke, he's talking about those 4 parcels.
Which 4? So again?
4 described at 109. Because in the end, Austin didn't decide what to do with those 4, how he was going to distribute them. And I'll show you the circumstances in which he then said, give them to Van Dyke. He said to Diane, give them to Van Dyke.
I see.
But 2 of them were already in Van Dyke's ownership, 46 and 47.
Well, save that Van Dyke had at least, by this agreement beneficially, given his ownership to Austin in return for other lots, not amongst those 4.
Yes.
So what they ended up with was 9 and 4.
In 106, we see the request for the full ownership of certain plots which were jointly owned. And the deal was at that stage that 46 and 47 would go back to Austin, who would also retain 122 and 177. But that the transfer back to Austin never took place because Austin said, take those 4 plots.
Yes.
Okay.
And in fact, the evidence was that if Austin had said, right, I want of those 4, I want this one to go to this daughter, this to this daughter, then they probably would have executed separate deeds for that rather than have 2 consecutive deeds, which is why they were waiting until July 2007 to have the deeds executed. And I showed you the chronology that set out by the judge at page 92 and 93 of his judgment. and he summarises A, the delay, and B, Vandyke's reason for it. I just emphasise that because the judge was aware of the difference in the dates between August 2006 and July 2007, and he was aware of, he understood the explanation for it. Now, the decision in 2007 came after some strife between the sisters Della and Diane, and the judge deals with this at page 113. He makes findings about that. Della, one of the respondents, had been struggling to take control of Austin's affairs from Diane. And we can see what the judge says about that, page 113.
Paragraph
85.
So at 83, Della purports to produce a letter said to have been dictated by Austin, revoking Diane's power of attorney. Paragraph 85, the judge says, I don't believe Della's evidence that Austin dictated that letter. He goes on to recount what Della said, at paragraph 85, and then to say how he found Della. And then he goes on to make findings about Della's attempt to take control of Austin's affairs, if I can paraphrase it, at paragraph 86. So I'll let your Lordships and your Ladyship read paragraph 86. And over the page he says, I don't believe that Austin dictated any letter of revocation.
Well, it goes beyond that, doesn't it? He revokes Della's power of attorney, and this was presumably is in after April 2007.
Yes.
And he knew exactly what he was doing.
Yes. Della had been putting it about that she had a power of attorney, and according to Diane's evidence, when Austin found out, he was upset, and he revoked it. And Diane takes up the story at 1431. I mean, 1430 just is the background we've just been discussing. But 1431 is really where I want to go because it's the moment of Austin's decision. Della, having withheld Austin's passport, finally returned it to him, paragraph 40. But Austin said up to his daughter Diane, I have the passport. And then he said, transfer the lands to Vandyke. So that is important context, that it was at the resolution of some strife between the sisters that had upset Austin.
And the lands we're now talking about when he said that are which plots are you then talking about? Are we talking 46, 47, 122 and 177?
It's the last four.
Yes.
And they, in your submission, are the only ones that aren't otherwise accounted for, so to speak. These are gifts.
Yes.
And on your submission, they are the only ones that could conceivably come within
Yes,
an undue influence.
yes.
But you say it was all done in Vandyke's absence.
And that's the other.
He was presumably thousands of miles away.
He was indeed. And we see that, the judge refers to that. We might as well go there now. I'm going to return here talking about his findings on the presumption of influence, but paragraph 97 at page 117, I'm really looking at item 5 there. It's a little bit awkward, and the grammar's a little awkward. And the paragraph begins by saying Diane's email described these things.
Sorry, which page?
Page 117, paragraph 97. But item 5, items 4 and 5 are not described in Diane's email. Item 5 is after Diane's email, but the point the judge makes at item 5 is that on that day, the 19th of July, when Austin gave the instructions for the lands to be transferred, Vandyke was in California. The decision was made by Austin with Diane in Vandyke's absence.
You say they are the only lands that we're concerned with effectively in this case.
In that deed.
Yeah.
Then we have the other deed, the half shares.
Oh, right.
Now,
So that, but it's four you say 4 lands out of the 13 in one deed.
Yes.
Were given in these circumstances where Della and Diane, there was strife between them, and he sided with Diane on that matter, revoking Della's alleged power of attorney. Yes.
when Vandyke was in the United States.
And Vandyke was in California.
For my own note, because I hadn't noticed it, could you just give me the 4 plot numbers? I'm sorry.
Yes.
46, 47, 122 and 177, I think.
Thank you very much.
Thank you. Yes, that's right.
Thank you.
Now, the other deed, the half shares, now that transfer, the main asset transferred by the other deed was the half share in the North Shore lands. Now, that cannot be said to be a gift by Austin to Vandyke either. For one thing, 25% was Sheila's, and for the other, Vandyke had
Settlement.
Yes. Vandyke had maintained throughout the proceedings, he acknowledged he was holding the North Shore lands on trust for his sisters in accordance with his mother and father's instructions.
Okay, because
Well, did he not send at least some correspondence where he claimed he had an interest as well? I think I saw it at some stage when reading into this. But your position is that he has acknowledged
Yes.
that he holds that property
Yes.
in trust for his sisters.
Yes, and the judge understood that.
Were all 3 sisters, or just?
Well, I'll show you how Vandyke described it to the judge. The judge acknowledged Vandyke's statement that he was holding those lands on trust twice in his judgment. A good example of what Vandyke said in oral evidence is at page 981.
901.
981.
981, thank you.
And it might be better. It might be better simply to look at what Austin said in correspondence. It might be clearer. But what he's saying is that his father's 4 acres, if they were to be sold, a 1 acre share would go to each of the 4 sisters. And he said his mother had given him his instructions. I can show you where he recounts his mother's instructions as to her 4 acre share. But of course, the possibility was that it wouldn't be sold for a while. It would be developed in cooperation with Mr. Montplaisir. Oh, I've got a bad reference. I may have to come back to the reference. I've just found a bad one. Sorry. 2nd of May. 2nd of May 2008. Beg your pardon. I need to be efficient with my time, not get Vandyke, 2nd of May 2008, 1883, I had 1833.
1883?
1883. So those are the instructions of each parent with respect to the North Shore lands.
Yes.
So in paragraph 3, the father's share, as you say, were to be held in trust for each of the sisters to the extent of 1 acre each.
Yeah.
And yet, I see what I was misremembering is the next paragraph, which relates to the mother's share.
Yes.
The mother's instruction, where
there's a problem with the arithmetic there, because if
the arithmetic doesn't really work.
you need to either delete a sister or delete the half after in 1.5 acres for the arithmetic to work. But
16.
in any event, Vandyke has no interest in the North Shore land.
Well, she seems to suggest that the mother's one wouldn't go to Diane.
That's right. The remaining acre was to be distributed among her poorer relatives by Vandyke in his sole discretion. So, by the second deed, the only land being transferred beneficially to Vandyke was the half share in the 2 plots 51 and 52. And the evidence as to those was they were being jointly developed with Mr. Montplaisir.
So the half share in
51 and 52, the minor part of the deed transferring 3 half shares.
Sorry, where?
yeah, that's the deed at 1837.
1837.
Yes.
51 and 52.
Yes.
The half shares, they are being transferred beneficially to Vandyke for the purposes of a proposed development. What Vandyke might do.
He's holding on trust.
Yes.
Everything on the North Shore. Yeah.
North Shore.
4B4, whatever it's called.
Yeah. 44B4, I think, is the whole of the North Shore.
Yes, that's the North Shore.
Yes.
So I hope I've explained the 2 impugned transfers.
Yeah.
And shown why the Court of Appeal is wrong to say they were gifts of 16 properties. Now, hopefully we can run through the judge's findings. I'm going to start at page 87.
So there were no, so far as the 13 are concerned, you're saying there were no gifts there at all?
The 13, there were 4.
There were 4, sorry. Right.
They were the California ones, one might label.
But
The bedside gift ones.
I see.
Transferred at the end of the day while Vandyke was in California.
Yes.
Yeah.
in the context of a row between Della and Diane. Yes.
Well, Della and Austin.
And Della and Austin, yes.
So I'm beginning, the judgment begins at page 86 and 87, is it? 87, 86, 87, 87, 6. Sorry. Paragraph 3, I just drawing attention to how the judge described the massive material before him.
Yes.
Because I'm just bearing in mind the task of
This is the great
judge. Behemothing.
adjective.
I
Yeah.
haven't seen that word before,
No,
but
not right.
I like it. So, yeah, I'm just bearing in mind the task of the first instance judge and all the material that he had to familiarise himself with. And we'll see that he developed his familiarity with material over the course of proceedings because he was the case management judge too. Dealt with applications to exclude evidence, for example. And then, page 89, I'm just referring at the top to the end of paragraph 9, this is the judge's first reference to the lack of evidence to support the claimant's claim that Austin was suffering from weakness of mind and senility.
But there's never been any suggestion he didn't have mental capacity to do all these things.
Indeed. Yes. But somewhere between capacity and full strength of mind might be relevant to
Yes. Yeah. For vulnerability.
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 Indeed, yes. Paragraph 89. Page 89, paragraph 11. I just draw your attention to how the judge took the claimant's evidence and then I'm going to go on to the judge's findings on undue influence. So we begin at page 99, paragraph 43. So this is the question the judge first asked himself. Was there undue influence in having Austin execute the power of attorney? And I accept that wasn't the only question before the judge on undue influence, as I'll go on to discuss. But then I just draw attention to the task the judge set himself at paragraph 45. I must carefully sift through the evidence, looking for any acts on the part of the defendants that can be said to amount to the exertion of influence over their father.
And this is before he became the solicitor, before Vandyke entered into these.
I'm going to say before and after in the end, but at this point,
Yes,
before,
yes.
So this is the stage of, if you like, Vandyke's conditions, first amongst which was power of attorney. And the judge says at the bottom of paragraph 46, the last sentence that goes over, he makes a point which he makes on a number of occasions. The lands weren't in Austin's name.
Yeah.
It would have had to be Diane who made the transfers with cooperation of the owners being Martina, Loretto and Montplaisir. But then the judge says how he approaches the issue at the end of that page to succeed with the claim. Della and Beverley must establish Vandyke exercised undue influence in respect to the power of attorney. Now, I don't adopt the same narrow view of the issues with respect to undue influence. I accept that they have to include whether undue influence operated on Austin's later decisions to transfer land to Vandyke. And I also accept that if the judge only made findings at this point in time, they would not answer that second issue. But I will now go on to show that he made findings of wider application which apply to Austin's later decisions. And he found Vandyke and Diane did not exercise undue influence at any stage. So, to demonstrate that, let's first see the findings he made about that point in time. And before we do, paragraph 47, that's important background.
So this will be in 2005, basically.
So yes, we're dealing with 2004. The first findings are about undue influence in 2005. But 47 is important, is a background finding of general application. Austin was no pushover, might even be considered to be And then 48 and 49, I won't go through them in detail. They discuss Vandyke's imposition of conditions, which was said to demonstrate the exertion of undue influence. The judge's conclusions are over the page at 102, at 50 and 51. And these are at the moment in time, these are in early 2005, we're still at now. So at that point, Vandyke was hardly in a position of trust or confidence. Or 51, at that moment in time, Vandyke held neither. That moment in time being early 2005. Then we go, but then at 52 we have a finding of general application, Vandyke's credibility. And 52 ends with the finding of no undue influence with respect to the grant of the power of attorney. Now 53 and 54 are important findings about Austin's control after the grant of power of attorney.
Just before you go on,
yes,
the framework the judge has set himself is an actual undue influence case in which he's seeing whether the claimants have demonstrated abusive conduct.
Yes.
Yeah, thus far.
Yes.
Yeah.
Well, he says...
Because he calls it actual, he labels it actual undue influence, and then his description of what he has to do is to see whether the claimants have proved their case.
Yes. Now...
Because at that time there was no relationship between Vandyke and the father which could give rise to a presumption.
Yes.
That must be right. But in terms of abusive conduct, my lord, it's not as though the judge is only looking for some gross undue influence. If you look at what he says at paragraph 54, he puts it in a number of different forms of words, but they're not all as if you like, as abusive as the other. And he says anything that can amount to the exertion of influence over their father is what he's looking at.
I was simply using it as a shorthand for undue influence.
Okay. Well, I suppose the reason why I emphasise that is because maybe there's this fear that if you're distinguishing between actual and presumed, you're calling actual something more gross than presumed. But
No. Actually, it's just...
I don't think... I'm saying the judge doesn't make that wrongful distinction, if you like.
It's proof of the actual exercise of undue influence.
Indeed.
Yeah, we don't need to get into using terminology of abuse.
Indeed. The reason I mention that is because I see some points in the Court of Appeals judgment where maybe they do treat actual as being more gross than presumed.
Yeah. Or a sort of commission rather than omission, yes.
Yes.
Now, I was Yes. After page 103, paragraphs 53 and 54, these are important findings about Austin's control of decision-making after the grant of the power. So he made Diane sign an agreement that she would consult him on everything. And the judge makes his findings about that in paragraph 54. He still wanted to call the shots. Now, the judge then turns to Vandyke's other conditions. So he returns to, he's now making findings again about early 2005 and about the other conditions Vandyke imposed. And he makes findings in respect of each of them. So, paragraph 56, the transfers of land to Diane, free exercise of Austin's will. 58 is about the half share in 157 that was given to Vandyke as payment for his time negotiating with Montplaisir. And then 62 is about the transfer of parcel 48 to Diane. So these are all 2005 findings. But this is where from here we now move to the time to the period of Vandyke's negotiations on behalf of Austin and the decision making of Vandyke, Austin, and Diane. So first of all, the judge considers allegations about Vandyke's conduct of negotiations, that's at page 63, and about where the properties should be transferred. Complaints made of Vandyke there. '67 then is a further complaint about the negotiation and partition with Montplaisir. And then 70 and 71 is Vandyke's decision to settle with Montplaisir and the fact that he had to persuade his father to agree to that. And then 72 is findings about that and about the relationship between Vandyke and Austin and about Vandyke's credibility. So they are important general findings at 72. And then the judge's conclusion on Vandyke's decisions on behalf of Austin is at 73. I'll go over the page to 110 because there are also some general findings there about Vandyke's conduct towards Austin.
I 73 is still talking about the negotiations.
Yes.
To settle this dispute, isn't it?
Yes. And then the judge deals at 75 onwards with allegations of coercion and physical intimidation. And he makes his findings about that at 75 and 76. 76 is also an important finding about Della and Beverly's credibility. The allegations they were prepared to make. They deliberately sought to mischaracterize Vandyke's actions in order to succeed in this claim. Severely undermine their credibility. Now, 77 and 78 are important because this is the judge accepting Diane's evidence about the decision-making relationship between the three of them, and especially between Vandyke and Austin, but also between the three of them. So she's a truthful witness, and Austin still had a strong independent mind. He didn't always like Vandyke's advice. And then 78, about the decision-making procedure between the three of them. So this plainly covers the period after the grant of attorney. This is, I say, about the decision-making relationship generally. Then, over the page at 112, the judge returns to the issue of Austin's mental competence, and at paragraph 80, his accountant's evidence as to his decision-making. And then 81 and 82, I say, are the general findings on undue influence.
80 is his impression, having heard the oral evidence of the accountant.
She gave oral.
Yeah, he says that's the impression, because the accountant's evidence was on the whole was fairly technical, as I recall. But the picture he says that was painted was that he was competent to give instructions in relation to business.
Yes.
Yes.
And that he's the one who gave her instructions, not Vandyke or Diane. Middle of the paragraph. Yeah. So then paragraphs 81 and 82 are what I say are the general findings on undue influence. And I say it's clear from the context and the supporting findings we've just gone through. This is a finding applicable to Austin's decisions generally, and Vandyke and Diane's role.
So at the time, in 2005, when the power of attorney was given to Diane, where was Austin physically?
In St. Lucia.
He was in St. Lucia. And did Mr. Rambali give evidence or not?
He provided an affidavit for the interim, in response to the interim relief.
Right.
Now, I don't know who had been prepared to give evidence at the trial. You will see at the end of the transcript the defendant's counsel saying, we're not going to call our other witnesses. So there may have been more on standby, but in the end, only these...
But his witness statement was not taken into account or read to the trial judge?
Not,
No.
Not as far as I can see from... I can check that.
So your essential point is that the finding on actual and undue influence is a general finding.
Yes.
It isn't confined to whether the power of attorney
Yes.
is exerted by actual undue influence.
We see that from the context that leads up to it and the supporting findings that lead up to it.
So I'm sorry, I just missed your exchange with Lady Rose. Who gave the statement at the interim stage? But
Mr. Rambali and Mr. Montplaisir.
Rambali.
thank you.
And Mr. Montplaisir also gave one.
Thank you.
So yes, I say that's a general finding. So, though there was some measure of reconciliation, it's not as if Vandyke was in a position of trust and influence so as to be able to overbear his will. And then he refers to Austin's motivations and concludes evidence doesn't support the finding there was any actual undue influence exerted on Austin by the defendants. Now, in answer to the point my Lord Burrows right at the start, in the context when the judge has gone through so carefully the relationships between the parties and different stages of the relationships and the decision-making process, he's not simply saying there's an absence of any evidence from which I can make a finding. He's saying there's no undue influence being exercised here. because he's been given a wealth of evidence about how the decisions were made, the relationships between the parties, the motivations, and the explanations for what was done. And just concluding with other important findings of the judge, over the page at 113, I've shown you already the findings about Della. So I'm then going to 114, where the judge turns to presumed undue influence.
Well, you're saying that that passage under actual undue influence, although it's carefully stated to be no actual undue influence, you say should be read in your submission as actually a finding that there was no undue influence.
No undue influence, in fact. In the context, given all the evidence the judge has been shown, he's made findings about how these relationships work.
And paragraph 87 is although it's relating to the revocation of Della's power of attorney, it's strongly suggestive that Austin knew exactly what he was doing.
Yes, indeed, yes. That's right, my lord.
As late as 3rd July.
Yes.
Yeah.
And was making personal decisions about what was going on.
Yeah, I mean, we're not talking about capacity, are we?
No.
We're talking about influence.
We're talking about influence, but nonetheless, it's his degree of control.
Well, that Austin decided what he wanted to do without being influenced by his children.
Yeah.
Yes. Thank you, my lady. I'm going to have to spin through what he says about presumed. But he first of all gives a reason for saying that presumed undue influence could not arise, which is one that I don't adopt myself. And at paragraph 92, at page 115, and over the page,
This is the third party point.
he says Austin wasn't the transferor. And then over the page he says, nor was he nor was he involved in any transfer for the benefit of a third party. Now,
Which paragraph?
it's 92, 94, 95.
Thank you.
I don't agree with that analysis of the transactions because, number one, as the Court of Appeal pointed out, Austin was a party to the two impugned transactions. He was the middleman. And in any event, he didn't have to be a party to make decisions over what happened to his beneficial share. So I don't agree with that analysis, but the judge does then say, in the event I'm wrong, I'll go on to consider the evidence of presumed undue influence. That's 95. Then he first considers whether the relationship between Vandyke and Austin was one of trust and confidence. And the claimant's claim is at 96, it arises from the relationship of loyalty. The court rejects that first because the claimant's case and the evidence, in fact, showed that there was no trusting relationship between Vandyke and Austin.
But it's a very odd thing to say that I don't feel able to manage my affairs, therefore I'm going to appoint someone to negotiate on my behalf and so on, and in the same breath to say I don't trust them.
Yes, well, yes, indeed, but we've also seen how the decision-making process worked. That every decision had to be run past Austin, who was calling the shots. And what Austin was concerned about was perhaps about physical weakness, and
well, I don't think I would read Diane's letter in that sense.
Perhaps not, but well, you're right to say that there are different currents, if you like, going on.
I mean, he's actually the agent of Austin. He's the agent in the.
He's negotiating with Mr. Montplaisir.
I mean, the fact there wasn't a fully trusting relationship is not enough, is it, to say there wasn't a relationship of trust and confidence there has to be between a principal and agent.
Well,
I mean, the law will
yes.
will so designate it, won't it?
Well, he clearly trusted Austin to go and do his best in the negotiation. Sorry, Austin clearly trusted Vandyke to go into battle with Mr. Montplaisir and do his best on behalf of Austin and the family.
Well, there your ladyship has
The question
it.
is whether there's a difference between that and trusting Austin's advice as to who to give the land to.
And if you made the point on behalf of Austin and the family, and what Vandyke very plainly said to Austin at the outset is, I'm doing this for my mother and my sisters, not for you. I'm paraphrasing. Mm-hmm. And Austin always, as Diane said, Austin always believed he was preferring his mother's interests. But it doesn't take away from the point your lordship's made. What I'm interested in is what the judge says at paragraph 97. Mm. Now, he doesn't deal with the point that your lordship's just made, or with whether there should be an irrebuttable presumption. But he does make findings, I say, which really prescribe the scope of any influence exercised by Austin in his role as Vandyke, in his role as lawyer. Communication was usually through third parties, instructions carried out through Diane, meetings were held with third parties present, minutes produced. So eyes were on the decision-making from all sides, as we've seen. And the actions of Vandyke weren't clandestine. Claimants knew what was going on. That's evident from the deluge of emails exhibited. And then, of course, the point I made earlier, when it came to the specific decision, Vandyke was on another continent. So, what I said at the outset was, if one must presume that Vandyke's role gave him some influence over Austin, one has also to ask, in respect of what matters, in particular, did Austin repose trust in Vandyke? And in respect of what decisions did Vandyke have influence over Austin? In other words, one has to understand how the relationship worked in practice. And the effect of the judge's findings here, given how the relationship worked, how decisions were carried out and made, there was in fact very little scope for Vandyke to exercise influence over Austin, especially in the operative decision in July. I would also make this further point. Those factors listed at paragraph 97, they're also powerful factors in support of the finding of no undue influence in fact. For the same reason, there was no scope for it in respect of this decision. Now, so the judge said at the bottom of that page, 117, I don't consider it necessary to go on to consider the second limb, that is, explicability. But in fact, he did so. He did so at paragraph 102. So he finds that all the transfers to the defendants, plural, were explicable. Then he makes a number of supporting findings. And you can see that he's referring to later transfers to, and to transfers to Vandyke.
So, as I understand your submission, on the first question, whether there's a relationship of trust and confidence, you're saying, as I understand it, or your submission, is that this is a far cry from a normal lawyer-client relationship.
Yes.
Insofar as one can apply that relationship idea at all, it's in a very limited scope. If one's then turning to whether on the facts a trust and confidence is made out, then you say, no, it isn't.
And I would say,
that is in fact what the judge said.
yes, and I would say even if there was trust and confidence in respect of some matters, there was no scope for the exercise of that influence in respect of the operative decisions, the impugned decisions. And that's an important third point.
Thank you.
So the judge's reasons for saying these transfers were explicable. And then over the page 103, this is hardly an unfamiliar or unusual occurrence in such circumstances. And I would say, what reason is there for gainsaying that overall assessment? After the judge has...
I'm trying to understand what he's saying there.
He's saying Austin's decision to give lands to Vandyke is explained by all the matters he lists at 102 and 103. And he says a decision like that would hardly be unfamiliar or unusual.
And what he says is slightly odd language. He would have left everything in the hands of the two children. That rather suggests leaving them to sort things out. But what you read it as saying would have given everything to the two children.
Yes.
I see. Right. Okay.
Well, we can look at...
in context, I can
Yes.
see. It's just, it struck me as a very odd phrase to use. But anyway, that's what you said.
Well, remember that some are held on trust and some are not.
Well, he says left everything to the children.
Yes.
Yeah.
But 102 is really about dispositive decision making.
Yes, yeah.
103
102
is more about the administration of his affairs, isn't it? Left everything in the hands of his two children. It doesn't mean given everything to his children.
Well, that was my question.
Yes, I certainly read 103 as talking about handing the administration of the affairs to the children.
Exactly. Yes.
Well, I read it just as because it followed directly on from 102. That
Yes, I thought you
he's
did.
making a
What he's saying is that whereas
supporting-
one might expect him to leave, or expect a parent to leave everything equally amongst their children, we all know that doesn't always happen, and in this case it may not have happened, and he's explained why.
And he's right to say it's hardly unusual or unfamiliar. And finally, two more relevant findings of the judge at page 122. This is where he's discussing separately the claim of unconscionable bargain. Just paragraph 113. Vandyke didn't act unconscionably in his actions towards Vandyke. That's relevant. I'm going to have to spin through the Court of Appeal's errors. I suppose I've got a little more than half past, and perhaps I can cut into some reply time too.
You can eat into your reply time, but you have another, according to my computer, 12:28, but we started 5 minutes late, so you have 7 minutes before you eat into your reply time.
Thank you. Right, well, let's go to the Court of Appeal. So, the Court of Appeal identifies its issues, page 318, paragraph 11. There really are only four. Four is the one that concerns us. And the Court of Appeal's discussion of undue influence begins at 327.
Before I forget, there's no dispute at all between the parties that the same law applies in St. Lucia as regards undue influence as in England and Wales.
That's right, my lord.
Thank you.
So, the central issue. Now, over the page, paragraph 41 is where Justice of Appeal Michel says that he's going to treat actual and undue influence, actual and presumed undue influence, as distinct.
Yes.
And then at the end of paragraph 42, that's the point made by my Lord Burrows. When oral evidence is given, the issue for the court is whether on the totality of the evidence, including any appropriate inference, it finds the transaction was in fact brought about by undue influence. That's also the case for presumed undue influence, and indeed the appropriate inferences he describes there, if there's a presumption, the presumption leads to those inferences. But he then goes on to treat presumed undue influence at 43 as a distinct category. Well, he's said at 41 they're distinct categories. Now, there's a discussion, he then goes into a discussion of the law, which doesn't really need to detain us, because at paragraph 48 he says that...
Well, does he go wrong at 45 when he says that...
Oh, yes.
Where he refers to the need to obtain independent advice.
That's the first time he makes the error of saying that the presumption is to be butted by independent advice. He doesn't allow for the possibility of alternative means of rebuttal. We'll see that again later on. Then he then discusses whether circumstances in which all the elements might not be required. But at 48, he does say that all three elements are part of the equation in this case. So that's a confidential relationship, a transaction that can't be explained, and rebutting the presumption, which he again says is by independent advice. And then he goes on to discuss how the presumption arises in this case. And he says, on any view of the evidence, the transfer of 13 parcels is a gift that can't be explained by ordinary motives, if I can use the short.
Sorry, which paragraph are you at?
Paragraph 49.
49.
And this is where the mistake first appears. He's describing it as the transfer of 13 parcels of land to Vandyke. And then he goes on to describe at paragraph 50 how valuable these are. And at 50 he goes on to describe the other deed, the 3 half shares, which includes the North Shore lands. And he describes how valuable the North Shore lands are there. $2.9 million, he estimates the value of the North Shore lands.
The half share?
The half share, yes. 16 acres, yes. None of which, of course, was going beneficially to Ike. And then at paragraph 52, he gives...
That's because Vandyke, as you showed us, accepts that he holds those for the benefit.
Yes, the property in the North Shore was considerably bigger than the relevant properties in the South Shore, because the relevant properties in the South Shore, I think, was 220,000 square feet, which is just over 5 acres.
Yes, but I do accept there were some valuable plots within that. Some were better for development than others, and my learned friend's no doubt going to show you.
Yes.
Value
but in any event, your principal point is to cite legal errors.
Yes, indeed. And paragraph 52 is where his reasons for finding these gifts to be explicable only by undue influence.
Yeah, it's quite clear from the bit of 52 on the top of page 333 that the Court of Appeal is thinking that the whole of the content of that deed is a gift.
And he even says so. The 16, at the bottom of 332, he says the 16 parcels of land transferred to Vandyke. I mean, well, the legal title, of course, was, but beneficial ownership was different. And then he rejects what he says was Vandyke's explanation. 52 and 53. He says, beggars belief. And he says the explanation is that Vandyke said made these gifts of land to him out of gratitude for the work which he'd done in negotiating with Kenneth. So that didn't make sense because Vandyke got paid for that. Therefore stretches credulity to its very limits. So the judge was bound, he says, to have found this could not be explained by the ordinary motives.
But it goes beyond that. I mean, the appeal court judge is calling Vandyke a liar.
Yes, indeed. That's
when he's had a badge of credibility by the trial judge, and there's absolutely no explanation of the basis on which he has rejected the trial judge's assessment.
Indeed. And I will add, he pays no account, or he doesn't appear to acknowledge at all the explanations given by the trial judge, nor indeed those given by Diane. He's also unwittingly calling Diane a liar as well, because she gave a much fuller explanation of her father's reasons for doing this.
Yes, I mean, her witness statement corroborated Vandyke on the essentials.
I'll quickly spin through. I'm just going to go through the findings before I summarise on the errors. But then the relationship of influence is considered over the page, and it's said to arise simply because of the relationship of lawyer and client. And the conclusion at 56, if you like, I pick up the point I made earlier about the scope of the influence, because it's not a question in the Court of Appeal's mind. So he simply says the trial judge was compelled to find there was a presumption of undue influence by Vandyke over his father in procuring these transfers.
At the end of 46, we're back to independent advice.
Back to the mistake that independent advice is the only way to rebut. Then he goes through whether Austin did receive independent advice. I won't go through those. And he concludes at 61 that it wasn't open to the trial judge to make a finding that Vandyke didn't, as the lawyer, legal advisor to his father, exercise undue influence over him.
Sorry, where's that?
61.
61. Thank you.
There was one point, the point I was going to make about the judge missing, the Court of Appeal judge missing the point about the scope of the influence is really at the bottom of page 333 in paragraph 55. Because he simply says that the relationship of lawyer-client was sufficient to establish that Austin had the confidence in Vandyke that would place Vandyke, this is the important bit, in a position to exercise undue influence over his father in making such a gift to him. So doesn't consider the scope of the influence, which is another, he has to answer that question too before he can reach that conclusion. So there are two main headings of errors here. The first one, which I discussed at the outset, treating presumed undue influence as a distinct category instead of an evidential presumption, and failing to appreciate that the judge's finding rebutted any presumption. And secondly, even if the presumption had a role to play, the Court of Appeal erred in finding that it was raised because its findings in support are infected by many serious errors, principally ignoring the inconsistent findings of the judge and overturning, or rather dismissing the evidence of two people who explained the transactions who the judge found to be credible, and for the reasons we've gone through already, seriously misunderstanding the relevant circumstances, what was being transferred and when. What was being transferred by who to who. But to deal with presumed undue influence, there's a lot in Ettridge on whether one can find on the impossibility of finding presumed undue influence if the judge after trial has found there to be no undue influence. I might not have time to go through all of the speeches of their lordships, but let's see, 2532.
You've set some of these out in your case, I think.
Yes.
You set them all out, actually.
Yes. So perhaps I
You would probably also say they're reasonably well summarised by Justice Lewison in his article.
Indeed. And by your lordships in Nature Resorts in that short paragraph. But one of the interesting points...
What is or where does it come in, if at all, the fact that Vandyke was not only his lawyer, but also his son? Where does that come into the equation in looking at undue influence?
It doesn't prevent a relationship of trust and confidence arising from the lawyer relationship. If one were to say that the presumption's irrebuttable, then the relationship of father and son wouldn't make a difference. It was said in this, that said, I've already made my points about the facts and how the influence could have been exercised in reality. And the family relationship is just another element of that. Diane said in her oral evidence, Vandyke wasn't my father's lawyer, he was just a son who happened to be a lawyer. Yeah. And there was no formal retainer.
Well, is that really right? He was actually paid to do the work.
Yes, he was paid.
He got plot 157, I think.
Half of 157.
Yeah.
Yes.
So I concede there was a relationship.
Did he actually get fees?
No, he got half of 157, my lady. I concede that he called himself.
He says he was his lawyer.
Yeah. And he said he was trusted to negotiate with Montplaisir. Yeah.
Just ask you took us to paragraph 53 of the Court of Appeal, where they referred to Vandyke's evidence was essentially that his father made these very substantial gifts to him out of gratitude. Do we know what evidence the Court of Appeal is referring to there? Yes,
and it's an incorrect summary of Vandyke's evidence.
Right.
It's at page 1455. We've seen the paragraph before. It's 109.
I see.
So
it's referring to those four.
And he says, yeah. He said, we did speak about these transfers before his death. And then he goes on to explain.
He says he was very pleased with the results of my negotiations with Mr. Montplaisir.
He was confident I would look after my mother and my sisters in his absence. So although there wasn't a trust actually imposed on these lands, Vandyke did feel a moral obligation to look after his mothers and sisters. And his evidence was he actually sought to offer these to his sisters in a meeting in October after the death. So that's Vandyke's explanation. I should show you Diane's as well, because hers was fuller. It's at 1431. paragraph 41.
Paragraph
41.
Oh, yes.
So this is the evidence of Diane, who was with Austin when he made the decision.
Yep.
1431.
1431.
It goes over the page.
Add it to
So, yes, Justice of Appeal Michel has misunderstood Vandyke's explanation. He's ignored Diane's explanation, and he's ignored the judge's finding that these transfers were explicable. And of course, the other error in coming to this finding is a misconception about what was being transferred. I've gone through the details of that, but Justice of Appeal Michel is very substantially wrong in saying these were gifts of 16 properties by Austin to Vandyke. And that doesn't just infect the analysis of presumed undue influence, it also makes the Court of Appeal's orders a grave injustice, because they have ordered that all 16 parcels of land are in Austin's estate.
And can I just be absolutely clear in my own mind? I'm sorry if I'm just going over what you've already told us, but you say of the 13 in one deed, it was only the 46, 47, 122 and 177 that could conceivably be regarded as gifts. And am I right in saying that it's also the half shares in 51
Yes.
and 52? So we're really talking on your submission about 6. Yes, thank you. And the 4 that you said earlier, that they were made when Vandyke was in California, is that applicable also to the 51 and 52?
Well, Vandyke didn't give specific evidence about his father's decision in that respect.
Yeah.
He says this was property being jointly developed with Mr. Montplaisir in the name of a company, a jointly owned company.
Thank you.
Now, I would say that's the kind of property that's governed by Diane and Vandyke's explanations, that he was trusted to look after his mother and sisters with the family properties that were being developed. But Vandyke himself didn't give evidence about his father's decision in that respect. I think I've covered what I wanted to cover. I did mention briefly the Court of Appeal's obiter finding that if it hadn't found undue influence, it would have found a trust. Can I just leave that to my written
Leave that
case?
for reply, if you want.
But it's in your written case.
It's in my written
It's
case.
in your written case anyway.
2338, 2339.
Yes.
May I just turn my back?
Yes, given the late start, you've used, I think, about 12 minutes of your reply time.
Thank you, my lord.
Thank you.
Thanks for the guidance.
Thank you. Mr. Onishabi.
Lords, good evening. I would first like to take the board to paragraph 49 of the electronic bundle, which essentially has Vandyke's defense to the claim.
You say page 49.
49 of the electronic bundle. was filed against Vandyke and Diane Jude. The defense that was put forward by the appellant was that Austin had no lands and he could not therefore create a trust over any lands. So he denied completely that there was any trust arrangement. In our statement of claim, and if we are to look at paragraph 49, the third paragraph, he says, with the exception of the transfer of parcel 157, the assumption relied upon by the claimant is a false assumption. AJ did not own the transferred lands. He therefore could not refer to lands he did not own in a will or create a trust over such lands. Austin Shield Limited also did not have an ownership interest in the lands. At page 50, if we are to look at paragraphs 5 and 6, the defense that he pleaded, there are two properties on parcel 48, both of which were built by defendant number 2. The Marigold lands, which include the disputed July 23, 2007, are lands which were purchased for value by defendant number 2 from Kenneth Montplaisir over a period of time from 2005 to August 2008. The paragraph that follows reads, "It was the tangled web of lies and deceit woven by AJ over the course of his relationship with Sheila that caused the need for defendant number 2 to intervene and negotiate a final partition with KM. AJ had already considered that he had no interest in these lands, and neither did his company, Austin Shield. He made this concession in numerous documents during the course of the proceedings." At page 51, paragraphs 3, 5, and 6.
SJ there is Sheila, presumably.
That's correct, my lady.
Paragraph?
We are looking at paragraphs 3, 5, and 6. At paragraph 3, he says at page 51, paragraph 3 is admitted except for the allegation that the second named defendant, defendant number 2, who is the appellant, was at all material times the legal advisor to Austin Jude on matters relating to Austin finances and immovable property, and except for the allegation that Kenneth Montplaisir held lands on trust for AJ. So here he's denying that Kenneth Montplaisir held lands on trust for Austin Jude. At paragraph 5, the third line, with the exception of parcel 157, none of the challenge transaction concerned the properties belonging to Austin Shield or Austin Jude. Paragraph 6, the second sentence, at all relevant times, the Marigold lands was registered in the name of Kenneth Montplaisir. Austin Jude was not allotted and not entitled to the Marigold lands listed. The last clear record of Austin Jude's position in relation to these lands is that he had no property interest in them. Austin Jude denied that he had any interest in the Marigold lands. In our statement of claim, we made an allegation that the lands were being held on trust in the alternative by the defendants.
But in paragraph 7, he's saying effectively that Austin Jude denied that he had any of this land in the course of the divorce proceedings, and now he should be prevented, or you should be prevented from asserting that he did. Yes.
Did these arguments form any significant part of the trial itself?
Yes, my lord, because that was the case. The allegation that lands were held on trust, or the North Shore lands were held on trust, that only featured in the witness statement. At no point prior to the filing of the witness statement was that allegation made. It was revealed in documents in a letter that Vandyke had written to his siblings. But when it came to responding to the claim, he emphatically denied that he was holding any lands on trust or that he was holding the North Shore lands on trust. So for the purposes of establishing that assertion was never made, there was never any concession that the North Shore lands were being held on trust when he filed his defense. And in your defense, you have to tell us the case that we have to meet. If you were holding the North Shore lands, there's nothing that prevented you from responding to your defense to say that. Now, I would just like to take the court.
The point I was making, it's my fault for not making it clear. Was the allegation that in some way that Austin's estate was stopped from, it would have been stopped?
There was that allegation.
Yes, but did that form part of the trial, or had that just passed away as an issue?
During the trial, I'm not so sure that it came out, but in the judgment, the court said that he could not, he would have been prepared, and if I may look at the judgment, the trial judge said, on the issue of trust.
It's not so much the issue of trust, but the paragraphs you're referring us to seem to be an assertion that Austin had no interest at all in the Marigot lands.
That is what the claimant, that is what the defendant was saying in the court below when he filed his defense.
But that wasn't part of his witness statement or the trial, is that right?
Well, in the trial, he said to the judge, to the court, although I'm holding the North Shore lands on trust for my sisters, if I win this case, they get nothing. He emphatically made that statement to the judge. And I can take the court to the transcript that goes with that.
Yes.
That's at page 1018 of the electronic one.
1018.
1018 of the electronic.
Thank you very much.
At this point in time, my lords, my lady, I'd just like us to have an overview of the lands in question. Actually, before I do that, I think it might be better to go to the July 23rd transfers, which deals with the two deeds.
Sorry, can we?
The two deeds, the two disputed transfers. If we can go to those.
Sorry, I'm still looking at page 1018.
Oh, that's a transcript. So it's lines 5 from line 5. He says, whatever, that is not true. If whatever my feelings are of my sisters and they are bitter, what I promised my father I will do, I will do. And it is true that if things go for me, if the decision in this case is that the lands were allotted to me by my father and mine, I will not give it to them because that is my state of mind.
Well, that's a very general statement. Is it made in the context of looking at the North Shore, or is it?
It was just made against the backdrop. There was a letter that was read in evidence, and he responded to the letter by saying what he feels about the North Shore lands.
But he'd written in May 2008.
Yes, my lord.
Page 1883, I think it is, acknowledging that in relation to the North Shore lands, there were instructions about the benefits which his sisters should obtain out of it.
Yes, my lord.
Which he was accepting, as I understand it.
He was accepting, but
there's maybe something wrong with the maths, but we have that right at the start of the dispute, don't we?
But he said he was holding it on trust, but with conditions as to how he uses it. He has total control over it. He determines whether or not it is sold. It was not a basic constructive trust. I'm holding it. When you are ready, you're going to get it. I'm holding it on trust, but with the authority to do as I please. At this point, I'd like to take the court to the two transfers. It's at page 1847.
Would this be a convenient place to adjourn for the short adjournment?
Pardon, my lord?
Would this be a convenient moment to adjourn for the short adjournment? Well, that's what we'll do. Thank you very much. We will resume at 2 o'clock.